Good morning, everyone. Okay, so for today's newspaper now, the first news that we are going to take up is on page number 1. That is Supreme Court restricts retrospective environmental clearances. So now with this news, what can be seen majorly if we try to understand the news as such? What's the idea? The idea has been that first thing, the environmental clearances when we talk about. So talking about environmental clearances, the first thing that we have the related legislation, that is Environment Protection Act. So Environment Protection Act, EPA 1986 is there, correct? Apart from Environmental Protection Act now, EIA notifications came out in 2006. Now about EIA notifications, that is Environment Impact Assessment. This Environment Impact Assessment notifications, now it mandates for a certain category of economic activities to get a prior environmental clearance. That's first thing. And secondly, we will deal with how the EIA process works. But basic idea abhi tak is the industry, say for example, mining as an activity. So if you are starting mining, prior to that itself, you have to take environmental clearance from the government. That's EIA notification 2006. Now, recently in 2021, through an office memorandum, what the government did was, government allowed for the post facto clearances. Post facto clearances, how does that work? Suppose I have to undertake an economic activity. What I can do is, I already start the economic activity. I already start the mining. It may have some degradation effect on the environment and all. And once it is found out, then I tell government that, okay, I'll take environment clearance. And then I'll apply for environment clearance and then I'll get the approval. Now, this is what government allowed for through a office memorandum in 2021. Okay. And this is what the Supreme Court is taking up now. So overall idea over here, first thing, how and under what conditions environmental clearances are required, that is one thing. But along with that, most importantly, if you talk about these post facto clearances would mean what now for the environment? That environment already has been damaged, and then you are taking the clearance. So that makes no sense now. Secondly, more importantly, if we talk about the principles which are involved over here, the principles basically is straightforward. One, that would be the sustainable development. That comes in conflict with whole of this idea. Secondly, polluter pays principle. So polluter pays principle says that if I have been responsible for any pollution, I will have to pay for the damages. That is called as polluter pays principle. So polluter pays principle now again would be diluted here, because what you are saying is I can start a project, I can degrade the environment, and then after that I may say that, okay, now you can give me the clearance. So whatever has happened prior to that, now that is not has been accounted for. So that is the challenge. Then apart from that, most importantly, precautionary principle. A precautionary principle overall in the environmental conservation aspect is where even when the damage has not occurred, as a precaution, you check certain activities. You take steps even before the damage has happened, just because there can be apprehensions that it may damage the environment. That is called as precautionary principle. Precautionary principle has been used in a number of cases with respect to environment or climate. Say, for example, Montreal Protocol. Montreal Protocol is related to ozone layer depletion. Montreal Protocol is ozone layer depletion. So when Montreal Protocol was taken up, during that time, the reports, final reports did not came out. What is the main reason for the ozone depletion? So reports still were awaited, but applying the precautionary principle that let's not wait for scientific research, the final report, and let's start acting on it now only. Later, when the findings come up, you may modify your approach, but you should start right now itself. Don't wait. And that is called as precautionary principle. This whole idea clearly violates the precautionary principle, because EIA, Environment Impact Assessment or Environment Clearance, is all about precautionary principle. That even when the project has started, I have to take the assessment that what can be its impact on the environment, what can be the damages, not that what has been the damages. There is a difference. So a priori only, you identify what can be the damages, and based on that, you provide the clearance or you may not. But post facto, when you are giving the clearances, that clearly violates it. And then most importantly, what Supreme Court is examining right now, apart from everything else, is the rule of law. Because EIA notifications, that came through legislative route. And it was notified properly under the EPA 1986. So it had a statutory backing. So that is the rule of law, let's say. Now, if you are overriding it with just an office memorandum, so then it bypasses that whole route which is there. So that is precisely what Supreme Court is right now examining. And that is whole of the news all about. So first, let's write few things about it. Okay, basic informations, and then we will read the news to understand it better. So first, environment clearance. Environment clearance. Right, the prior approval required for certain projects. Prior approval required for certain projects, such as mining, comma, thermal power plants, highways, dams, airports, etc. Next point. Parent law is EPA 1986. Parent law is EPA 1986. And the detailed framework comes from EIA notification 2006. EIA notification 2006. Next pointer, ex post facto EC, environmental clearance. Ex post facto EC means project starts operation first, and environmental clearance, environment clearance is sought later. Is sought later. Then at the principles involved. Principles involved. Under that first precautionary principle. Under precautionary principle right there is steps taken even before. Steps taken even before actual damage occurs. Even before actual damage occurs. Second, sustainable development. Third, polluter pays principle. Polluter pays principle. And fourth, rule of law. Rule of law. Rule of law में put a hyphen and mention. Administrative convenience. Administrative convenience cannot override a statutory environmental framework. Environmental framework. Now let's talk about this environment impact assessment. So environment impact assessment, as we have said, EIA notification 2006. Okay, it provides for the framework for environment impact assessment. And how does it work basically? Is where first thing that is done, so stage wise we will see. The first stage is screening. First understand over here how it happens, then you can note down. Okay, first screening happens. Okay, screening के बाद scoping happens. Now screening and scoping, what do we mean by that? Screening simply means identifying which projects require EIA. And who will tell it? The notification. What will tell it is notification. So notification has mentioned few classes, few of them you have written. Okay, which one require EIA? So that would be first identified, whether this project requires EIA or not. Okay, once that is done, then scoping is done. Scope, what is the scope? Scope would mean scoping is the process where what aspects of environmental impact we have to check. What aspects would mean that if suppose there is a thermal power plant, the thermal power plant में what aspects of pollution we have to check? Water pollution we'll have to check, air pollution will have to check. These two have to be checked. Correct? This is scoping. So there are water pollution, air pollution, land pollution, or any other such type of degradation when happens. You identify which parameters you have to check. Okay? That is scoping. After scoping, next one you do is baseline data collection. Now, baseline data collection, what is it? Baseline we are talking about. So if I am proposing that I'll start my operations, I am seeking approval. And in my DPR, detailed project report, it is mentioned that I'll start operations 2 months from now. So I'll start my operations, let's say from 1st of September. So once I start operating, there can be changes that may occur, correct, to the environment. But how will I measure the changes? For that, I need to have a baseline. If there is a river flowing nearby. So I'll check right now how much is the pollution level without the industry or operation. And so later when I'll file the report, when the monitoring would happen, they will check against this base level. So baseline data is collected regarding the present status of the surrounding. Okay? After that, the impact assessment is done. Okay? How much would be the impact overall? So as of now, at this stage, so it can be predicted only. So over here, impact prediction. Now, once impact prediction has been done, it will impact the environment in such a way. After that, all of this goes to public consultation. So public consultation may the surrounding population where the operation has been proposed, okay, they need to be consulted with all this information that, see, this is what we are going to start in your area. Okay, this can be the impact. So what do you say? Of course, on one hand, you will see that if you tell the impact, people will say no. But that is not how it happens. Okay, because any operation is starting over here, it will generate employment also. It will benefit local people also. So local people's local population see it in that manner, that how we should take it. Cost benefit analysis would be done. Once public consultation has been done, then it will go to the appraisal committee. Now, which will take a call on it. A public consultation when happens, it should be recorded and it should be presented to appraisal committee, even with the objections, how many people objected to it, what were the exact nature of objections. And once appraisal committee, after that, once it goes, then clearance is given. Okay? Of course, after clearance, monitoring and review also takes place, so where periodically reports have to be submitted regarding what has been the actual impacts. So these are the stages associated in environment impact assessment. Understood? So note down the stages. Tell me the meaning of these two. Screening is what? Whether the project needs EIA or not. Scoping is what? Which environmental parameters need to be studied. So basically the idea why Supreme Court is opposing it, two factors. First is the question of law, where we have said rule of law, because this is an administrative order. Okay, it cannot override a legal factor which arises from a notification, legal notification. Okay, that's one thing. Secondly, what it says is it cannot become a perpetual measure. Okay, the amnesty can be there. Yes, of course. Why not? Okay, amnesties can be there, but amnesties, if you follow, that's why I gave you the principles. Okay, amnesties can be there, but amnesty should follow these basic principles like polluter pays principle. If you're giving amnesty, what about the damage that has already been done? Okay, so that is needed to be compensated. So you have to collect fine from them. You can should impose fine on them. Okay, collect for what the damages have been done. So that is one thing. And it can be one-time offer. Okay, in many cases it happens. Say, for example, in normal cases where common people are involved, let's say, for example, income tax itself. Income tax may, if something happens, government provides a window. Okay, that we are giving 1 month window. Okay, you can submit the fines and settle everything. So these things can happen, but they can be one time. They cannot be perpetual in nature. Okay, that is what Supreme Court is right now telling about it. Okay, done? No, it would not be judicial overreach as such, because in those cases, judiciary itself would be following certain principles. Okay, the principles that we said. So you cannot define it as judicial overreach. Yes, of course. Okay, because it came through administrative order, the executive order purely. So it bypassed the legislative path. and therefore judiciary intervenes in that. Okay, but in case of amnesty also, it can go through the court. No issues in that. Now the second news is related to, so second news is given on page number 9. So page number 9, where the news is guidelines issued for planned re-entry of space objects. So related to this news, what all we have to know is the first thing, in space. So in space, the organization now which is there, it has released these guidelines. So our first task would be to know about this. Very, very important or probable question for the exam, in space as an organization. And second, about the guidelines itself, we will talk about. So first thing, that is the in space which is there. What is in space? Okay, in space is a organization, it's a government organization. Okay, and what it deals with? Private sector. So wherever private sector operators are involved, okay, to regulate it, to manage it in space is a arm which has been created. Okay, that is first thing. So first thing, that it is a government body. Okay, it works under Department of Space and deals with the private operators. So in space is what you can write there, Indian National Space Promotion and Authorization Center. Space Promotion and Authorization Center. With respect to private sector space activities in India. Now, what does it say is the planned re-entry. Now, planned re-entries can be planned or re-entries can be unplanned. Unplanned is where the objects may fall into the Earth's atmosphere, okay, without any prior plan, okay, accidentally, or that is unplanned re-entry. And then there is planned re-entry. So these guidelines have been given, of course, for planned re-entry. And what does it say? That for any planned re-entry, the operator would need authorization, pre-authorization of in space. So they have to get the authorization for the planned re-entry. That's one thing. Secondly, the guidelines would be applicable to Indian agencies. Not just operating in India, whether the operation is being carried out in India or abroad as well. But if Indian agency is involved, then they will have to get the authorization from in space. So even when, say, for example, this becomes very important from the recent Vikram launch. So if this company launches some from any agency abroad also, then also, because it is an Indian agency, it will have to get the authorization. That is the requirement. And with respect to that, the guidelines have been given. Guidelines are, of course, authorization. Why authorization? Because over here, the falling objects may become a risk for humans also. Falling objects may become a risk for aviation sector also. And therefore, in all of those cases, authorization is a must. So that is the guidelines issued by whom? By in space. For whom? For private sectors. In what case? Planned re-entry of the space objects. And it applies to Indian agencies, whether operating in India or abroad as well. Okay? So you can note this particular part down. See, India playing a role, Indian agency, if it is involved, then if any accident happens, okay, it's because it is related to space sector, okay, Indian government would be questioned on that. And basically the rules are regarding when the re-entry is happening. So even re-entry, whether it is taking place in the territory of India or outside, launch would be from India only. Okay, but the re-entry wherever is happening, suppose we get the re-entry into Pacific Ocean. Okay, because that would be the window where it can be re-enter anytime from anywhere. So when the re-entry happens, it happens within Indian territory or outside Indian territory. That is what is covered. Okay, so you can note it down. These guidelines apply to Indian entities. These guidelines apply to Indian entities planning to bring back space objects whether within or outside Indian territory. हो गया? Read the news. चलिए, from here now, moving on to page number 13. Page number 13 now. Rajya Sabha passes bill to criminalize disrespect to Vande Mataram. Okay. Now this news, this particular bill right now has been passed from Rajya Sabha, and now, so it was introduced in Rajya Sabha. It has been passed by Rajya Sabha now, and it is going to go to Lok Sabha now. So this whole thing arises from Prevention of Insults to National Honors Act 1971. Ab National Honors Act, what it deals with, which national honors first of all. So as the act envisages, what are those honors, national honors, when we talk about? The national flag, constitution, and national anthem. Three have been covered under the act. So flag, constitution, and national anthem. Along with that, if you see constitutional position, Article 51A, that also talks about the fundamental duties. And fundamental duty of every citizen to abide by the Constitution and honor the national flag and the national anthem. Constitution में जो लिखा हुआ है, it is a national flag and national anthem. So Constitution talks about flag and national anthem, as well as the Act, Prevention of Insults to National Honors Act 1971. It talks about these three. Article 51A talks about national flag and national anthem. Okay. Now this amendment which has been, so it is an amendment to this act, nothing else. So this 2026 amendment, now it wants to extend it to the national song also, which is Vande Mataram. That's first of all what is happening right now. Secondly, apart from that, of course, with respect to this, now we have to talk about Vande Mataram. So Vande Mataram as a song originally appeared where? Anand Math by Bankim Chandra Chattopadhyay. So Bankim Chandra Chattopadhyay's novel Anand Math, in that this song appeared, and this novel was released in 1882. These are very, very important facts with respect to history. So, Vande Mataram appeared as a song in a novel, Anand Mat, by Bankim Chandra Chattopadhyay. That's one thing. After that, in 1937, it was adopted by Congress, okay, a Congress committee, as national song in 1937. Not any Congress session as such. Okay, there was a Congress committee, Jawaharlal Nehru recommended it, and it was adopted as a national song in 1937 at Calcutta. Congress Committee, 1937, Calcutta. Okay, and one very important information is when it was adopted at that time, not whole of the song was adopted as national song, only first two stanzas were adopted as national song. Because the rest of the stanzas were associated with the religion, basically. Religious deities were invoked in other stanzas. So for that reason, there were oppositions and only first two stanzas were adopted. Okay, everyone? This is the history behind it. So first thing what we will do is, Google it, everyone, quickly. Prevention of Insults to National Honors Act. It's one pager only. Prevention of Insults to National Honors Act. And don't read any commentary. I need the act. Found there, the act? One pager, I think, or two pager? One. So read through it quickly once. Interesting read, actually. Okay, done. So understood all of the idea behind it. This is all what can be asked. Now moving on to the editorial page, page number 10. So page number 10 is now a commentary on FCRA. So FCRA we have covered earlier also in the class. Okay, Foreign Contribution Regulation Act. So FCRA Act originally dates back to 1976. We have FCRA 1976. FCRA 1976. Okay, but the parent bill with respect to these amendments which are there, that is 2000. So FCRA Act 2000. So that is the parent bill. It replaced the FCRA 1976. Now in 2000, so FCRA 2000, this is the parent bill now. And eventually 2020 May FCRA, there were amendments that were brought to this, making the conditions more stringent. Now, two or three things to understand, although have done once in the class already earlier. FCRA do not cover all the NGOs. FCRA covers only those NGOs who receive foreign contribution. So any NGO which is operating in India and receiving any form of foreign contribution, the requirements say that they will first have to get registered under FCRA. So they have to get FCRA registration. Along with that, the 2020 amendments which were there, it mandated these organizations to have a bank account at SBI New Delhi, okay, in which they are going to receive the money. Then along with that, what was done, that administrative expenses were reduced from 50% to 20%. And third thing, that the contributions which you are getting from the foreign funding, okay, it cannot be freely transferred to any other NGO. This was done to check the trail. Otherwise, the trail becomes very difficult. A common path is multiple trails are created. Okay, you get the money in one account, then you transfer it to multiple NGOs, and then from there, the tracking becomes very difficult for the agencies. So what are the things that were done? First, registration was required. Okay, second, the administrative, the bank account needs to be opened. And third, that is the administrative expense reduced from 50% to 20%. And the funds cannot be freely transferred to other NGOs. Receiving foreign funds. Okay, FCRA has nothing to do with all the NGOs. Hmm. Yeah. No, but them also, only those who are receiving foreign contributions. Okay, that's why the Act FCRA. Okay, you may have multiple branches. That's what we said. If one particular NGO has branches in Kerala as well as Karnataka, both receiving foreign contributions, both will get registered, but both will get registered separately. One in Karnataka, one in Kerala. And they need to have 2020 amendments ke baad, okay, they need to have an account at SBI New Delhi separately, jahan pe contributions would be credited, fund would be credited. Okay, that's one thing. Understood the part? Now, what is the new amendment trying to do? New amendment 2020 mein to I told you these provisions which made it much more strict norms. The new amendments now which have been introduced, it is trying to deal with the assets that are created from those foreign contributions. What does it say? It says, and I'll give you one example. Okay, suppose a charitable college. A college is opened. A college is opened, which means a educational society, a trust was there, first of all, a educational trust. And now this educational trust is receiving contribution from abroad. So this educational trust may be doing a lot of things because it would be registered as an NGO. And now it is receiving the contribution. Now from the contribution that it received, from that, suppose it has constructed a college. So now I will say a asset has been created from the funds. Now what happens that after a while, let's say renewal is required of FCRA registration. If the NGO fails to get the renewal done, or its FCRA registration lapses, or it itself now surrenders its FCRA registration. Because once you are FCRA registered, you are under a lot of scrutiny. A lot of documentation is required. You have to submit a lot of reports to government regularly. So if you are now not getting any foreign contribution, no use of having those certificates or registration. So I may voluntarily surrender the FCRA registration. In any of these cases, now the new rules say that the assets, even after this, the assets which were created using the foreign contribution, okay, they would now be administered by a separate body. They will not belong to you permanently. This is what the new amendment is talking about. The new amendment is about the assets created from the foreign contributions. The proposed amendment which is there. Now, what are the arguments here? Arguments, civil society says that this is an attempt of the government to take over the assets of NGOs. Because government will designate authority and that authority now will take care of those assets. So civil societies are arguing that government will take over our assets. Because assets once when they were created, then we were registered. And it came definitely then through legal route, let's say. So there was no question of illegality as such. Okay, but then you taking over the assets, that is government trying to capture the assets, take over the assets. What the government is arguing that if you have created some asset, once your funding stops due to any reason, and you do not have the FCRA registration now, once your funding stops, operational gaps start coming up in the assets. Even I gave you the example of college. Okay, if now the funding is not coming, the proper running of the college, the administration operation of the college, that may be hindered. So government is saying that foreign capital, okay, related assets which were created, to bridge the operational gap only, we are handing it over to designated authority. That is one thing. Secondly, government can revoke the FCRA registration. Under what conditions? It says one, that is administrative, one, documentation and all are not proper. Second, in national interest. A national interest is very ambiguous, nowhere defined, and it is up to government to define it in case-to-case basis. So national interest may, suppose national safety comes into concern. Okay, there is, and it do happen that there is a lot of foreign fundings that happen. Okay, and it is a part of diplomacy where a lot of countries try to destabilize other countries. So under those conditions also fundings come, and fundings can take, and they do take, the most easiest route, that is NGOs. So NGOs of a lot of other countries operate in other countries. And basically it is how the funds are routed into other countries. So if the question of national security, national interest, larger public interest, if that comes, then in those cases, government can cancel or revoke the registration as well. So again, under those conditions, if the assets were created, okay, through this route, then that would almost become an illegal asset, which may come up later. So under those conditions, also the assets control go to the designated authority. That is whole of the idea. So this is basically two things that for which the opposition is coming. One, government trying to take control of the assets. That's one. And secondly, government introducing arbitrariness in terms of regulating the NGOs, in terms of revoking the licenses and all, in the name of national interest. Understood? That is the apprehension. On the other hand, what the government is telling, I told you, government is clarifying that it is just to maintain the operational aspect or fill the operational gaps which may come up in these assets post cancellation of the license or stopping the funding. So that is the overall, this particular article, it provides a perspective which is opposing the bill. So you can see FCRA Bill 2026, a threat to civil society organization. So that is only one side of the story we always have to remember. These are perspectives. So one will write this, another will write on another side of the story. Our answer has to be a mix of both. We'll not label it as anything based on one article. Okay, but you can now read the article and figure out the points. Again, the same approach we'll take. You'll mark it over there, 1, 2, that if you have to write critical appraisal or critique of the bill, how many points you can write, different points. Okay.
So after my trainer is not receiving anything for that, but getting confirmation from email.
It does not count. Can manage, but FCRA do not recognizes those contributions. Okay, FCRA Act says that it's purely FCRA registration. If that lapses, if that cancels, we'll take up the assets and give it to a designated authority. It provides a rule that later if you renew, if you are able to renew your registration and the later stages also, we'll give it back to you. Yes, absolutely. Either you need their continuous support or you need to maintain your registration at least. Yes, why not? Okay, it's not conditional on whether you are receiving it or not. Okay, you have to get the registration. If you are registered, there would be enhanced monitoring. That's the only thing. That's why we call them apprehensions. How people see the government, and you develop an idea of government agenda, what we start calling as agenda of government. When you look at from that lens, then everything comes with the apprehension, the motive, where it may be absent also. In some cases, it may be there. Okay, read it? Understood all the parts? So we understand from the article, this is one side of the story. Okay, so specific pointers which are there, but we will need it when we have to appraise the bill. So this is one side. Another side, I have already told you why government is doing that. Of course, while explaining this, we will bring into it the question of national security, the challenges of foreign funds flowing into India. Okay, and the role of NGOs anyways have for long been questioned. A lot of NGOs. Okay, this is not just this time. Okay, from very long time ago, and a lot of NGOs have been found to be involved in that also. It is almost another route similar to Hawala route, just that it comes through a legal showable means or route. Okay, with a garb of in the garb of something else. So pro side also, we have a lot of arguments, strong arguments which are there, that government always needs to have very strong regulations with respect to foreign contributions. And it's not just in case of India. Okay, every country do have very strong regulations, including USA, including European countries. In any countries, regulations are very strong related to foreign contributions. So why not in India? Okay. So, okay, then that's it for today. Okay, this was all the news. Thank you.